Hi, I'm attorney Greg Dell with the law firm of Dell & Schaefer, and I want to talk to you about an issue that we're seeing a lot in many cases across the country. And it also is an issue that's been coming up in a lot of long-term disability insurance denials. And that has to do with disability insurance carriers wrongfully applying the 24-month mental nervous limitation clause. Now, this is a case that took place in the Eastern District of Pennsylvania recently against the Prudential insurance company. Now, the 24-month mental nervous limitation clause that I'm referring to is a clause that says if your disability is caused or contributed to by a mental nervous condition, then you're only entitled to 24 months of benefits. Now, usually a mental nervous condition has something that has to be defined within the disability policy, and very often they'll say that it's any mental condition that can be found in the DSMV, which is the Diagnostic Statistical Manual for Psychiatric Conditions. Now, this particular case has an interesting fact pattern, and in every case you have to understand what the facts are of the case and then apply the law to them. In this case, the claimant had been involved in a very serious motor vehicle accident which resulted in a traumatic brain injury. And as a result of the traumatic brain injury, the person claimed that they were disabled. So they never said that their disability was a mental nervous condition. What they always told Prudential, and what Prudential paid them for at least 24 months, was the person had a traumatic brain injury, and as a result of the traumatic brain injury, they ended up having cognitive deficiencies. Now, there are obviously numerous mental conditions that can cause a person to have cognitive impairment. And a person who has cognitive impairment means that they have difficulty processing, difficulty remembering things, difficulty with multitasking. But that doesn't mean that because you have those issues that makes it a mental nervous condition. In this particular case, and what Prudential always understood and what the claimant's doctors conveyed to Prudential, was this was a result of traumatic brain injury. And a traumatic brain injury means that this person actually had damage to their brain as a result of the automobile accident, which makes it a physical injury and not a psychiatric or non-physical injury. In this case, when Prudential was reviewing the records, the claimant and the claimant's son were involved in the same motor vehicle accident. And mistakenly, because the claimant and the claimant's son had a junior and a senior name, the son's medical records ended up getting stuck with the father's medical records. And the father was the one who had the claimant in this case. So throughout the medical records that were reviewed by Prudential, they were consistently referring to medical records of the child and not the actual claimant. And the claimant had told Prudential on more than one occasion that you're looking at the wrong medical records. Those records don't apply to me, the claimant. So for example, in one record it says that the claimant never lost consciousness. Now, in many people, we've handled numerous claims for people with traumatic brain injury, and one of the most common things when it comes from an accident is whether or not the person had a loss of consciousness following the accident. And that's important because anytime anyone loses consciousness, there could be brain damage, which means there could be a lack of oxygen to the brain. So in this case, Prudential and their doctors were trying to say, well, we don't really think there could have been any traumatic brain injury because there was no loss of consciousness. And when the court got into looking at all the medical records and understanding that Prudential's doctors were relying on the wrong medical records, even though they had been told that these weren't the right medical records, the court ended up coming to the conclusion that, look, you paid this claimant for 2 years. Your actions to say that he doesn't have traumatic brain injury now with no medical evidence to support that he doesn't is arbitrary and capricious. And as a result, your decision to deny his benefits is an abuse of your discretion and it's wrong. And the case was remanded back to Prudential with instructions that they should pay the claim. And unless they have any other evidence to speak otherwise, this person is disabled by a traumatic brain injury, which is a physical condition. Despite the fact that they have cognitive deficits, those cognitive deficits are causally related to the motor vehicle accident that took place. So if you have a claim and you're dealing with the issue of, do you have a physical injury, do you have a psychiatric injury that could be limited by the 24-month limitation, or you have any other issue that's going on with a denial of long-term disability benefits, whether it's Prudential or any other insurance company, call us for a free consultation or review of your claim. We'll be happy to discuss all of the issues with you, let you know how we can help you, and give you an answer within a matter of minutes as to whether or not we think we can help you. We appreciate the opportunity to work with you.